Welcome to What's New in Influencer Marketing in 2026. I'm Belinda McCauley, CEO of the Beverly Hills Bar Association, and I am delighted to be here today to introduce our speaker, Allison Fitzpatrick. Allison is a partner in the advertising and marketing practice at Davis+Gilbert, where she advises brands, agencies, and marketers on the rapidly evolving legal landscape of digital and social media. Allison has been at the forefront of influencer marketing since its earliest days, helping shape influencer contracts and social media policies as the industry grew from niche bloggers to major celebrity partnerships. She advises clients across the full spectrum of influencer relationships, from micro influencers to nationally recognized talent. She is a go-to resource for children's marketers and operators of child-targeted apps and websites, regularly reviewing campaigns, privacy policies, and digital properties for compliance with COPPA, the Children's Advertising Review Unit guidelines, and related laws. Her broader practice covers endorsements and testimonials, sweepstakes and promotions, claim substantiation, and truthfulness in advertising across all media. And now let's learn from Allison.
Thank you, Belinda. And thank you for attending What's New in Influencer Marketing in 2026. Next slide. I think you already were introduced to me, so we can go to next slide. So today we're going to discuss the FTC guidance on endorsements and testimonials, enforcement, the FTC, NAD, and class action litigation, virtual influencers and AI, kid influencers and child influencer laws, what provisions should be in your influencer agreements, and looking ahead, what's next and best practices. Next slide. When we discuss influencer marketing, we need to discuss the rules and regulations that apply to influencer marketing in the United States, most notably the FTC endorsement guides, violations of which may result in enforcement by the FTC under Section 5 of the FTC Act, which prohibits unfair and deceptive conduct. Next slide. Before we get into what is new in influencer marketing, let's start with the basics. So what is an endorsement? An endorsement is any advertising message, including verbal statements, demonstrations, or depictions that consumers are likely to believe reflects the opinions, beliefs, findings, or experiences of someone other than the sponsoring advertiser. An endorser can be an individual person, including an influencer, celebrity, or ordinary consumer, or a group or institution. But endorsements must reflect the honest opinions, findings, beliefs, or experiences of the endorser. Next slide. And what is a material connection? Under the FTC endorsement guides, when there exists a connection between the endorser and the seller of the advertised product that might materially affect the weight or credibility of the endorsement, and that connection is not reasonably expected by the audience, such connection must be disclosed clearly and conspicuously. So material connections can include monetary payment or the provision of free or discounted products to the endorser, regardless of whether the advertiser requires an endorsement in return. Material connections can also include other benefits to the endorser, such as early access to a product or the possibility of being paid or winning a prize or appearing on television or in other media promotions. Next slide. In 2023, the FTC updated its endorsement guides, which was a big development because the last update came in 2009, back when influencers were called bloggers. Next slide. Some notable changes in the updated endorsement guides include, number one, changes to the definition of endorser to now include virtual influencers and pet influencers, so not limited to human influencers anymore. Two, additional guidance on what is a material connection and when and how to disclose. Three, a new section on child-directed disclosures, as special care must be taken when including endorsements and advertising directed to children, which we're going to discuss in more detail later. And four, making clear that advertisers, agencies, and other third parties can be liable for their influencers' violations. Next slide. The most important changes focus on how to make a social media disclosure, as the FTC wants disclosures to be unavoidable. So what does unavoidable mean? Well, disclosures must be above the more button and not in a string of hashtags. If an endorsement is in the visual, disclosure should be made in the visual. If an endorsement is made in the audio, disclosure should be made in the audio. If an endorsement is made in both, disclosure should be made in both visual and audio. YouTube and online videos require disclosures in the beginning of the video and multiple disclosures throughout, depending on the length of the video. And built-in tools on social media platforms are likely insufficient. Next slide. So while you can use social media's built-in disclosure tools, you should not rely on them, as this comes directly from the FTC's endorsement FAQs. The question is, the social media platform I use has a built-in feature that allows me to disclose paid endorsements. Can I just rely on that tool? The FTC said, not necessarily. It's good that some platforms offer these tools, and we don't want to dissuade you from using them. But just because a platform offers this feature is no guarantee that's an effective way for influencers to disclose their material connection to a brand. The big picture point is the ultimate responsibility for clearly and conspicuously disclosing a material connection rests with the influencer and the brand, not the platform. So to be on the safe side, it's always best to add your own disclosure, even if the platform offers its own disclosure tool. Next slide. The FTC also provided guidance on what language to use to make a social media disclosure. Starting a post with hashtag ad or paid ad or advertising would likely be effective. Including the name of the brand and a hashtag with partner or ambassador would also likely be effective. But commonly used disclosures such as hashtag contest, hashtag sweepstakes, hashtag sponsored, or hashtag promotion may be ambiguous if they do not include a brand name. And avoid vague terms such as gifted, free product, and endorsement that do not include brand names. Next slide. Now, companies, agencies, and others involved in the ad making process could be liable if an influencer makes a deceptive endorsement or fails to disclose a material connection. Acting in good faith and providing effective guidance to influencers is not a safe harbor, but may reduce your risk of facing FTC enforcement actions. So you need to instruct your influencers about avoiding misleading statements and making proper disclosures of material connections. You also need to monitor influencers for compliance. You want to have a reasonable monitoring program in place. You need to address insufficient disclosures and terminate influencers who fail to comply. Always remember that companies and brands will likely be liable for the actions of their influencers. So it is important to ensure appropriate safeguards are included of all your influencer contracts, which we're going to discuss shortly. Next slide. So what are the key takeaways from the updated FTC endorsement guides? Well, make your disclosures hard to miss. Consider where you say, place it, and how it will look to consumers on the devices they're using by disclosing any material connection above the More button. If the endorsement is made through visual and audible means, the disclosure should be in both mediums. And keep your disclosures unambiguous. Vague terms in posts such as hashtag spawn, collab, partner, sweepstakes, employee, and free product are not sufficiently clear because a significant minority of consumers would not understand or expect that post was sponsored. Do not rely on built-in social media disclosure tools, and when in doubt, add the brand name to your disclosure, as the FTC really recommends that for transparency. Last, do not place your disclosure in a string of hashtags. Next slide. Now we're going to talk about enforcement. Why do we need to comply with these guides? Because of enforcement. Well, we originally were concerned about the FTC, Federal Trade Commission. Now we need to be concerned about the National Advertising Division, NAD, state AGs, and class action litigation. Next slide. Some of us thought that the FTC's updated guidance to the FTC endorsement guides may have been more of a best practice, but shortly thereafter, the FTC announced that it had sent warning letters to two trade associations, the American Beverage Association and the Canadian Sugar Institute, and 12 of their influencers, claiming that their influencers' posts were not sufficient. The FTC called out specifically that some posts included paid partnership, sponsored an ad, but did not identify the sponsor of the post. And while some posts included disclosures in the caption and description, they were not in the video itself. While some influencers relied on Instagram's paid partnership tool, which the FTC believes is insufficient. Next slide. If you look at the first example of one of the influencers who received a warning letter, her disclosure does not look too bad. We partnered with American Beverage Association and ad. But these disclosures were below the more button, and the video itself did not include any disclosures. And because the influencer made endorsements in both the audio and the visual, the disclosure should have been made in both. And if you look at the second example, hashtag sponsored, it says hashtag sponsored, but it does not tell you who sponsored the post. In addition, there were no disclosures in the video itself. Now, there's a major question whether the Trump FTC will enforce the FTC endorsement guides. But you still need to make sure you're following the FTC updated guidance, because even if the FTC does not enforce this guidance, the National Advertising Division, NAD, and class action attorneys are enforcing these guidelines and citing the FTC's guidance in doing so. Next slide. So now we're going to talk about the NAD. By way of background, the NAD is a self-regulatory organization in the United States designed to build consumer trust in advertising. Non-compliance is typically referred to the FTC, but if the Trump FTC does not take action, the NAD will likely start referring non-compliance to the state AGs in states like New York and California. Next slide. Over the past 2 years, the NAD has brought a number of actions involving influencer marketing, including this action against Drunk Elephant. The NAD found the disclosure Drunk Elephant Partner is not clear and conspicuous because it was only visible if the viewer clicked on the hyperlink more. The words in the disclosure run together, making it difficult for viewers to read and understand it. And the disclosure only appears in the text description, yet the endorsement was made in the video. So the disclosure should have been in the video itself. Next slide. Then the NAD also brought an action against Revolve Group, claiming its influencers did not include sufficient disclosures as they only included the hashtag gifted by Revolve, which was difficult to understand because of the words ran together. Another post stated, wearing Revolve, I think it's Lovers Friends LA, hashtag sponsored. The NAD argued that when multiple brands are tagged in a single post, it is unclear which brand is the sponsor. And while tags such as sponsored or promotion may be effective, the NAD believes sponsored by XYZ, with XYZ being the brand, and promotion by XYZ would be clearer for consumers. Now remember Revolve's name as it's going to come back later. Next slide. Now, NAD has also brought an action against popular comedian Kevin Hart for his social posts. Hart and the brands argued that followers are likely aware of his connection to these brands due to his long-standing and public endorsements. He's the public face for JPMC for 5 years, and he's an equity owner and face of Fabletics Men since its launch. However, the NAD determined that disclosure was necessary because a significant minority of the audience might not be aware of his connection with these brands. Next slide. Now we're going to talk about enforcement and class action litigation. Over the past year, we've seen a number of class actions involving influencer disclosures. So be on notice that failure to disclose may not only result in regulatory action, but now an expensive class action litigation. Next slide. So last time we saw Resolve, it was subject to an NAD action because its influencers failed to make sufficient disclosures. But Revolve's influencers' insufficient disclosures also resulted in a $50 million class action lawsuit. Luckily for Revolve, it was able to move the class action to arbitration because of its valid and enforceable arbitration provision in its terms and conditions. So you may want to double check your arbitration provisions as it could help you get out of the next expensive class action lawsuit. Next slide. Similarly, Shine is facing a $500 million class action lawsuit in which the complaint alleges Shine engages influencers to promote its products without disclosing their relationships to the company. Other influencers do disclose their connection to the company, but do so in a long list of hashtags that are only visible if the consumer clicks on the More button on the post. The complaint cites violations of the FTC Act, as well as little FTC acts in states like Illinois, California, and Pennsylvania. So in addition to Revolve and Shine, clothing brand Yalo Yoga was sued in a class action for $150 million, while energy drink Celsius Holdings was sued in a class action for $450 million as a result of their influencers' posts. So non-compliance now is getting very expensive with this class action litigations. Next slide. So now we're going to talk about virtual and AI influencers. Next slide. So what is the difference between virtual and AI influencers? Well, virtual influencers refers to any fictional computer-generated persona, often called a digital avatar, acting on social media. While AI influencers refers to a subset of virtual influencers that actively use generative AI and machine learning to draft their own posts, generate their photorealistic imagery or videos, and even chat with followers in real time. Next slide. The rise of virtual influencers started a few years back with Little Michaela. Little Michaela posted for years before she was outed as not being a real person. Now her profile page discloses that she is a robot, as shown in the slide. Could we play the video? As you can see, Little Michaela really does look like a real person. So the line between robot and real person is getting very confusing and very blurred. So when it comes to growing use of virtual and AI influencers, brands must think about transparency considerations with respect to disclosing the fact that the influencer is not a real person. Which leads to the next slide. What are the disclosure obligations of virtual influencers? Well, the updated FTC endorsements guides make clear that they apply to virtual influencers. So you need to have a hashtag ad or another disclosure to disclose your material connections. But because endorsements must reflect endorser's honest experience, if the endorser is not a real person and cannot have honest opinions or actual experiences, a disclosure that the influencer is not human should be included, similar to Lil Michaela. Failure to make this disclosure would likely violate the FTC endorsements guides and constitute a deceptive practice under the consumer protection laws. Note also that certain social media platforms such as TikTok and YouTube have adopted explicit requirements that creators label their AI-generated content. Next slide. So what are the benefits of virtual and AI influencers? Well, cost savings. Virtual influencers can deliver significantly lower campaign costs than top-tier human influencers. They do not require travel budgets, makeup artists, studio spaces, or complex contract negotiations. Also, content control. Brands can dictate the specific setting, lighting, framing, clothing, and script, often without any pushback. Also, output. A virtual influencer can shoot dozens of high-quality photos or videos in a single day, working 24/7 without sleep. And last, PR scandals. They typically do not post inappropriate personal content or create brand-damaging controversies. But note that some virtual influencers have more risque personas than others, so brands will want the right to terminate if the virtual influencer's endorsements or posts could cause damage to the brand. For example, Lil Michaela recently created a scandal by saying that she had leukemia, which of course was not true. Next slide. And what are some of the issues with virtual and AI influencers? Well, intellectual property issues. Disputes may arise who owns the IP rights in an AI-generated influencer's likeness, content, and persona. Is it the developer, the brand, or the platform hosting it? AI influencers modeled on or resembling real people may infringe on personality rights or the right of publicity. And under current U.S. Copyright Office guidance, works created solely by AI may lack human authorship and therefore may not be eligible for copyright protection. Another issue is lack of authenticity. Virtual influencers cannot genuinely use, experience, or endorse products, which may undermine consumer trust, may undermine trust with consumers if ever discovered. Next slide. Another issue, bias and stereotyping. AI-generated personas may perpetuate harmful stereotypes related to race, gender, body image, or other characteristics, exposing brands to reputational harm and potential liability. And last, displacement of human creators. The use of virtual influencer raises ethical questions about the displacement of real content creators and the economic impact on the influencer industry. Next slide. The last point is best evidenced by the controversy surrounding Sienna Rose, who shot to fame with over 3 million listeners on Spotify after releasing an implausible amount of music in a very short time, indicating that she's an AI performer, which has not been officially confirmed, nor has any one developer come forward to claim her, but it's pretty generally agreed that she is AI. Now, she has become representative of the debate over AI's role in the creation of music and other art, as well as debates over when and how this type of AI should be disclosed to the public. Next slide. Oh, we don't need to show the video. And if you allow your influencers to use AI to generate content, please consider the following. Ensure influencers are transparent as to whether and how they may be using generative AI in creating branded content and whether they are making appropriate disclosures. If using AI to create influencer content, you need to ensure brands have rights to the content and content is not infringing third-party rights. And be wary of utilizing virtual influencers or AI-powered influencer chatbots, as responses to consumers could provide misleading information about the products or violate FTC guidelines. Next slide. And if you're concerned about AI or influencers using AI, ensure your influencer agreement includes appropriate AI clauses such as this. Influencer will not use artificial intelligence in connection with the services, including in connection with the creation or use of any deepfake content, unless such AI has been disclosed to company and approved by company in advance, and only to the extent such use is in compliance with all applicable laws. Next slide. So now we're going to talk about kid influencers and child influencer laws. Next slide. Child influencers are still very popular. As I mentioned earlier, the FTC updated its endorsement guides to provide guidance, but only provided this single statement. Ads directed at children may be of special concern because of the character of the audience. Unfortunately, that really didn't provide as much guidance and is not very helpful. Next slide. Fortunately, afterwards, the FTC released its report from its kids advertising workshop, which included several recommendations, including 1, do not blur advertising, but provide a clear separation between kids entertainment content and advertising, and 2, provide prominent just-in-time disclosures. These disclosures should be provided verbally and in writing and should explain the commercial nature and intent of the message, such as company paid me to show you this, instead of paid promotion or sponsor content, which children probably don't understand. Next slide. When hiring child influencers, you need to be mindful of child influencer laws in the various states. In 2024, Illinois became the first state to enact a child influencer law, which requires that vloggers properly compensate the children who appear in their videos. The law creates a private right of action for child influencers against their parents if they are not properly compensated. Since that time, Minnesota passed a similar law that also prohibits children under the age of 14 from engaging in the work of content creation. Next slide. Not to be outdone, California passed 2 child influencer laws, one that is similar to the Illinois law and the other which expands the Coogan law protections to influencers and requires those hiring child influencers to implement policies to verify the existence of Coogan trust accounts and prepare to pay 15% of earnings directly into those accounts. Next slide. Utah also recently passed a child influencer law following the conviction of Ruby Frank, who gave parenting advice to millions on YouTube before her 2023 arrest for child abuse. You really can't make this up. Under the Utah law, online creators who make more than $150,000 a year from content featuring children will be required to set aside 15% of those earnings into a trust fund that the kids can access when they turn 18. Next slide. Similar to Utah, Arkansas, Montana, and Virginia have also amended their child labor laws to mandate trusts and other protections for content creators who are minors. Other states like New York and New Jersey have proposed legislation to expand protections to child influencers as well. Next slide. So what are best practices with child influencers? Well, you want to include the following clauses in your child influencer agreements. Parental guardian consent clause. This is because a child cannot make a contract. A representation and warranty regarding compliance with laws, including child labor and Coogan laws. Prohibitions against the collection of personal data, content restrictions and guardrails, an indemnity from the parent, and a release of advertiser liability if the parent fails to fulfill its obligations. And you want termination if the influencer engages in inappropriate behavior. Next slide. What are other best practices with child influencers? You still want to vet child influencers. I know they're just children, but all influencers should be vetted. Content. Your content must comply with KRU and FTC's disclosure requirements and language children will understand, such as this is an ad for brand X. There should be no bullying or racist, sexist, or discriminating content, no swearing or offensive language, and no unsafe or inappropriate content. You want to make sure all content complies with the Children Advertising Review Unit's, KRU's, advertising guidelines, which is a self-regulatory organization that monitors children's advertising, including influencer marketing. Next slide. So what provisions should be in your influencer agreements? A lot of what you can get into your influencer contracts really depends on your bargaining power. Next slide. When you first look to engage an influencer, here are some of the items that you need to consider. What rights do you need? Is it paid or unpaid usage? As that should be discussed upfront. Do you want analytics or performance-related metrics such as impressions or comments? And what are some of the unique issues with the influencer agreement? Regulatory and FTC compliance that we already discussed, brand guidelines, and you should make sure you give your influencer your brand guidelines. Wide range of content and associated production, ownership, and rights issues that we'll get into. Their public relations risks. As I said, you want to vet and conduct due diligence on your influencers, and you're going to want to have termination rights if anything arises, such as a scandal or improper content from your influencer relationship. Also be aware of the changing landscape. We already talked about AI influencers and some of the challenges that they bring, but we're going to talk about the ban on TikTok in a little bit. Next slide. You want to ensure your influencers have written contracts that include disclosure guidelines or a social media policy. And some of the key contractual issues to consider is ownership of influencer content versus license to use. If you have a license, you want to make sure your influencer contract is very clear as to the term, the territory, and the media. Another thing to consider is posting on brand channels versus posting by the influencer. Most brands want both. Also, do you want paid media? Do you want promoted posts, whitelistings? That should be discussed upfront. Exclusivity. Do you want to have exclusivity? If so, what type of exclusivity do you want? Is it within a category such as fashion or with a time frame, within 24 hours of the post? Review and approval. You are going to want to have review and approval rights because you're going to want to ensure no IP, disclosure, or other issues arise out of the influencer's content. Monitoring. You're going to want to monitor your influencers, and you're going to want to terminate influencers who do not make the requisite disclosures, as we've discussed earlier. Next slide. So one of the first questions you need to ask yourself, what services will the influencer provide? Well, the primary service is typically independent production of social media content and posting of such social media content. But are there other services you want the influencer to provide? Additional ancillary services, such as public relations activities, any media interviews, personal appearances. Discuss that upfront because you're going to want to make sure that's in your influencer agreement. Also, what are the content distribution channels? Is it Instagram, Facebook, TikTok? Where does the influencer have the most followers? Because that's where you want the influencer to post. Next slide. So one of the most important questions that should be decided at the outset is who owns the content. Next slide. When you're dealing with TV commercials, brands own all the results and proceeds of a shoot, while talent typically retains ownership of any materials they provided, such as their trademark or taglines. Um, Influencers typically own the results and proceeds of their services, while granting a broad license to the brand. The brand retains ownership of any materials it provides, such as the brand assets, including trademarks and products. Next slide. So the debate over ownership versus a license. At the beginning of influencer marketing, brands typically owned all influencer content as they had the most bargaining power. However, as influencers gained more bargaining power, they began owning the influencer content. Brands typically do not fight for ownership anymore, as a broad license is typically sufficient. However, creative studios still often require ownership of the content due to their assets being included in the influencer content. Next slide. As discussed earlier, ask yourself, do you want exclusivity? Not having exclusivity can devalue your campaign, so I highly recommend exclusivity. If so, what type of exclusivity do you want? Is it category exclusivity in fashion or pharma or another category for a certain period of time? Or is it complete exclusivity for a shorter period of time, such as 24 hours before or after a post? Next slide. Do you want to get approval rights? Yes. You want to make sure you have approval rights prior to the influencer posting so you can ensure compliance with the law and the post does not raise any IP or other issues. The FTC strongly recommends getting prior approval rights and putting it into your contracts in advance. Next slide. So how do you protect the company? What language do you put in your contracts to protect the brand? Next slide. Well, all agreements should require influencers and endorsers to comply with the FTC guidelines, but agreements should really drill down into specific requirements that influencers reflect their actual experience, requirement that influencers reflect their actual experience with the product or service, a requirement that all statements must be truthful and factually accurate, specific disclosure requirements, including the actual language and placement of disclosures in the endorser's content, and a requirement for influencer to immediately take down non-compliant content. Next slide. Your influencer agreement should have strong representation and warranties, such as the following. Influencer has the full right, power, and authority to enter into this agreement, grant the rights granted herein, and fully perform its obligations hereunder without violating the rights of any third party. The content is wholly original with influencer, and that the use of the content in accordance with the agreement will not infringe any patents, copyrights, trademarks, trade secrets, or other intellectual property rights, or violate the rights of privacy, publicity, or other rights of any third party. The content and influencer's performance of the service and all of its other obligations under the agreement will comply with the company's attached influencer social media policy. And you really want to make sure you give your social media policy to the influencer, and I would recommend attaching it to the influencer agreement. Next slide. Another rep and warranty that you want to make sure you're including in your influencer agreement Influencer will comply with any internet or social media platform's terms of use and policies when posting content on such third-party platforms. Influencer will comply with all applicable federal, state, and local laws, regulations, administrative guidelines, orders, and ordinances, including without limitation, the FTC endorsement and testimonial guidelines. And last, influencer will not disparage company or its products, services, or any other person or party. No disparagement of anyone. And you also want to have a line in there: in no event will company's approval of any content or activities relieve the influencer of its responsibilities under this section. Because just because the company approves it doesn't mean it should be responsible for it. Next slide. Ensure your influencer agreement includes appropriate influencer indemnities, particularly for influencers' breach or alleged breach of this agreement, and or any of the representations or warranties included therein. You want to ensure there's a rep covering IP infringement or include a separate indemnity for IP infringement. You also want to make sure there's an indemnity for influencers' negligence or willful misconduct. Ideally, we would like to get an indemnity for influencers' acts and omissions. And back in the early days of influencer marketing, you sometimes could get this, but influencers have gotten more sophisticated, or at least their agents and managers have gotten more sophisticated, and will usually push back on such a broad indemnity for acts and omissions. But I will try instead to at least get negligence or willful misconduct. I would try, if you're the brand, to avoid indemnities to the extent possible. This was easier to do in the early days of influencer marketing when brands had a lot more of the bargaining power. But if you need to give on indemnities as part of the negotiations, brands can typically agree to an indemnity for the content and IP given to influencers, provided it is used in accordance with the brand's instructions. Next slide. Brands also want broad termination provisions, such as termination for convenience, and that should not be mutual. It should only be for the brand. Termination for breach, but that is often mutual. That's pretty standard. And termination for morals clause violations. And you do not want to make that mutual if you can avoid it, as discussed herein. Next slide. Now, you want to ensure the agreement includes an appropriate morals clause, such as the above. If the influencer has committed, and make sure you get has committed because you want to get past acts, commits, is accused of, or is reported to have done, or is arrested for any act, which A, that is or shall be an offense involving moral turpitude under federal, state, or local laws. B, brings influencer or company into public disrepute, contempt, embarrassment, scandal, or ridicule, as reasonably determined by company. Or C, that is reasonably likely to injure the success of and or damage the reputation of company, or reduce the commercial value of influencers' association with the company, as reasonably determined by the company. Then at the time of such act, or at the time a company learns of such act, which is important, company shall have the right at its sole option to immediately terminate this agreement for breach by written notice to that effect. That's a model language that you want to make sure you have in your influencer agreements. Next slide. Now, you want to ensure morals clauses apply to acts that occurred during the term and acts that occurred before the term. In fact, way before the term. Examples such as in high school, as a lot of moral clause violations happen way before the term. So you want to make sure that you have the ability to terminate the influencer agreement if you learn of the morals clause violation years later. Any kind of morally reprehensible or offensive conduct, not just convicted crimes, but you want to make sure you can terminate if there's sex or drug scandals. It doesn't have to be a crime, but just a scandal that tarnishes your brand, and you want to have the ability to get out of the agreement. You also want to consider whether morals clause is broad enough to cover negative PR affecting the influencer, not just their own actions. And we raised this because a couple of years ago, HP, Sephora, and Estee Lauder all severed connections with influencer Olivia Jade following the Varsity Blues college admissions scandal that involved her parents, Lori Loughlin, and her husband, even though Olivia Jade technically really didn't do anything wrong. The reach of the morals clause should be broad enough to allow disassociation even when it's not the influencer's own behavior in question, but someone in the influencer's close orbit, such as with Olivia Jade. Next slide. So what happens when an influencer wants to terminate because of bad acts of the company, such as Kim Kardashian after her sponsor featured children in bondage gear in its campaign? Next slide. Well, Kim posted this tweet in response. I've been quiet for the past few days, not because I haven't been disgusted and outraged by the recent campaigns, but because I wanted an opportunity to speak to their team to understand for myself how this could have happened. Now, in the end, Kim stayed with the brand and became the official ambassador 2 years later. So she did not sever ties with her sponsor. Next slide. Which brings us to the question, should you have a reverse morals clause in your agreement? If you're the brand, I would say push back. And these are the reasons why. One, the brand is paying for the association with the influencer and not vice versa. The influencer is promoting the brand and not vice versa. Brands can have thousands or tens or hundreds of thousands of employees. And it just doesn't have the same reputational damage. If a company or a company CEO has a scandal, it's not likely to impact the company's influencers. Next slide. So if a brand has to agree to a reverse morals clause, make sure it is very narrow and limited to high-profile, public-facing C-suite executives. For example, influencers shall have the right to terminate this agreement immediately upon written notice to company if during the term or usage term, a high-level public-facing C-suite executive of company, which talent determines in good faith and in its reasonable judgment becomes a subject of public controversy, scandal, or disrepute, or otherwise takes or is the subject of any action which shocks, insults, or offends the community of talent, including without limitation, talent's audience, followers, and subscribers. So again, you want to make sure you limit it to high-level public-facing C-suite executives of company and not all employees, because most companies have thousands or hundreds of employees. Next slide. Looking ahead, what's next in best practices? Next slide. We may be safe now from the TikTok bans, but up until recently, you wanted to make sure your influencer agreements included language to address another TikTok ban if your influencer is posting on TikTok, as you want the right to terminate or move services to another platform, assuming the influencer has a similar number of followers on that other platform. So right now, I think we're safe, but if it comes into question again, make sure you look at your influencer agreements and has appropriate TikTok ban language. Next slide. So today's key takeaways. One, all companies should be reviewing their advertising practices to avoid violating the FTC endorsement guides. Two, remember that enforcement is not only through the FTC, but may be NAD, state AGs, and/or class actions. Next slide. The clear and conspicuous disclosure standard now incorporates unavoidable. If the representation is made through both visual and audible means, the FTC really wants its disclosures that's both in the audio and the video. When in doubt, include the brand name in the disclosure. In particular, hashtag sweepstakes or hashtag contest alone isn't enough. The FTC wants to say hashtag brand contest or hashtag brand sweepstakes. It's clearer that way. Be cautious of disclosures without brand names, such as gifted, free product, or endorsement. Next slide. If harnessing virtual influencers, remember that the definition of endorser has expanded to include them. And don't rely on built-in platform tools to make disclosures. Always include a separate, clear, and conspicuous disclosure. According to the FTC, when content creators want viewers to read something, they superimpose much larger text over their videos. Next slide. Make sure that advertisements directed to kids and teens include disclosures specifically designed to be effective for that audience. It should be in language that is understandable to children. comply with the influencer laws that we discussed, and you want to monitor influencer posts and do it regularly. The FTC wants to see that brands have a reasonable monitoring program in place. And last, frequently revisit your influencer contract and social media policies. Make sure you're updating them on a consistent basis so that they're in compliance with best practices and with the law. So I think with that, we have some time for questions.
All right, it looks like we have one question so far. Is there a preferred choice of entity for influencers to operate their business?
Sorry, can you repeat that question?
Yes. So is there a preferred choice of entity for influencers to operate their business?
Operate. Are they looking for the preferred social platform, or if that's the question, that there isn't a preferred social platform at all. It's really, they just need, if they're on a certain platform, they just need to make sure that their disclosures are clear and conspicuous and unavoidable on that platform. The FTC is actually in their FAQs giving very specific guidance how disclosures should be made on each social media platform. So the way they should be made on Facebook and X, Twitter, is different from the guidance they provided for like Instagram stories and Snap videos. So if you are curious about how to make a disclosure, I think the best place to look is the FTC endorsement FAQs, because they actually have language that's specific to each social media platform. And as we said many times, do not rely on the Instagram or Facebook built-in social media platform disclosures. As we've said many times, the FTC has found them to be ineffective.
It looks like we have another question. What are your thoughts on New York's upcoming enforcement on disclosing AI advertising?
I mean, I'm not surprised. I think we've been expecting something like that. As we saw with the slides I showed, the AI is getting really, really lifelike. And I think if there are, there, it's getting difficult to know what's real and what's not. And I think we're turning towards the need to have disclosures, because the line is getting very blurred. And I think for companies that are using AI, and when consumers find out, they may be, there may be some, downside to the brand, for the reasons I said, because they're taking business away from humans, as well as other reasons that I explained earlier. So I think I'm not surprised, and I think it's pretty much in line with some of the topics we discussed today.
Great. And looks like we have another question. Any suggestions for influencers when dealing with an ad agency or marketing company on behalf of the corporate sponsor?
Yes. So as I said earlier, that and this has been the case for a while, but the FTC has made it very clear in the updated FTC endorsement guides that brands and companies are going to be responsible for everyone in their ecosystem providing services to them. So in connection with influencer marketing. So that will mean their PR agencies and advertising agencies. And often the PR agencies and advertising agencies are the ones that are actually directly contracting with the influencers or the influencer networks. So there are going to be responsibilities on the brands to make sure that the agencies and PR agencies that they hire are doing their due diligence and making sure they're vetting their influencers. So one thing, maybe asking your agencies for reports, what's going on? What's the report on your influencers that they're hiring? Are they making appropriate disclosures? Are they terminating influencers who are not making appropriate disclosures? So yes, there are responsibilities now, particularly on agencies that are working for brands and companies, and the brands and the companies should be actually doing due diligence and following up with their agencies to make sure that they are complying with the FTC endorsement guides. And I think one of the best ways is maybe providing reporting and maybe taking a look at the contracts too, the contracts they have with their agencies. I mean, sorry, with the influencers, between the agencies and the influencers. That may be another place to start.
It looks like we have another question. Are there commercially available services for monitoring? How do you get timely information on times of influencer communications?
Well, I think there are influencer networks and there are influencer um, companies that they can, when you hire them, they should be able to provide you with those more of the automated system. I mean, as myself as a brand, we don't really have access to that, but there are companies, particularly if you hire an influencer network, they should be able to give you some type of automated reporting on the influencers that are working for you.
And then I have another question. For the newer state-specific child protection laws, is the applicability tied to where the child influencer resides when being engaged, where the brand operates, or where the work occurs?
Yes, that's a great question. And I think it's different in different states, but typically it's where the services are provided.
All right. And let's see. How should brands navigate campaigns involving teenage influencers who are themselves sophisticated creators, but whose audiences are largely children?
Oh, that's a really good question. Well, CARE, the Children's Advertising Review Unit, often talks about, even with teen influencers, they're very popular with children. So you really have to, with younger children. So they may actually have a very large children's following, and they may need to comply with something like the CARE advertising guidelines that we discussed because of their following. So if you are a teen influencer, I think you have to look at some of the CARE and COPPA factors, whether they're their videos are directed to children, because there could be an obligation to comply with CARE's advertising guidelines, which has the heightened disclosure obligations of, making disclosures in language that children understand, such as this is an ad for brand X. Maybe not using the words that most brands prefer, such as sponsored or things that are not as obvious as advertisement or ad. So I think you really need to take a look, because CARE would say a lot of children try to age up, and they really like having they really follow teen influencers. So you may actually have even if you're a teen influencer, you may be considered by CARE to actually, and maybe by YouTube, as directed to kids and maybe made for kids. If you really look at your demographics and you look at the content, is it subject matter that's directed for kids? What are you talking about? Are you talking about things like dating, which is maybe more teen or financial issues, or going to college, which is maybe for older teens? But are you talking about things like movies that are popular with younger children, with games, with storytelling, things like that? Because then you may fall more into the bucket of being directed to children and need to comply with the CARE guidelines we discussed, but we didn't even get into the YouTube made for kids, because it is possible that if you're a teen, your video, your channel and your videos may be deemed by YouTube to be made for kids, given your following and the content, the language you use, who you're speaking to, and whether you're just popular with younger children.
Let's see. Do you think the FTC's endorsement framework is technologically adaptable enough for AI-generated content in evolving platforms, or do you anticipate a more formal rulemaking process in the near future?
That's a great question. And I do anticipate a more formal rulemaking process in the near future. I think because really, if you look back, I don't think the FTC has really articulated many standards when it comes to AI. And even with AI influencers, I try to find, an official statement of what their policy is. And I think I've seen unofficial statements that there should be some type of disclosure that this person is not a human or that they're a robot. But I've yet to see something that's official. So I think we need something along those lines, because right now it's ambiguous what the FTC uh, position is. I think we know what it is, but it's ambiguous. And I think when it comes out with some type of rulemaking where it's clearer rules when it comes to AI, um, the industry will have a better roadmap as to what to follow. Because right now we're seeing a lot of AI influencers who are not making the proper disclosures. I mean, I guess that's Sienna Rose. Nobody to this day really knows whether or not he is a real person or not. It's most likely AI generated. So I think the rules are behind. Do I think it's going to happen during the Trump FTC? Probably not. The FTC endorsement guides have not been a huge focus of the FTC of the Trump FTC. But I think under the next administration, we'll probably definitely see more movement in rulemaking when it comes to FTC endorsement guides and AI. And I would probably have a whole section on FTC endorsement guides and AI.
Great. Thank you, Allison. It looks like we have another question. Um,
Okay.
what are your suggestions for interacting with other members of the influencers team, both when you were initially retained or on an ongoing basis?
Can you repeat that question?
Yes. What are your suggestions for interacting with other members of the influencers team, both when you were initially retained and on an ongoing basis?
I'm just trying to think from whose perspective. Is it from the brand's perspective, working with the influencers team?
Let's see. Yes, the brand perspective.
Okay. Hmm. That's an interesting question. I don't think I've ever been asked that before. Um, I think you just have to make sure that the influencer is aware of their obligations, and you may not be working directly with the influencer. You may be working more with the influencer's agent or manager or parent. So that needs to be the entity that you're working with to make sure that they are fully aware of the disclosure obligations, the compliance obligations, and make sure. I always think, one of the most important things is the social media policy. You know, the FTC has always said that the first thing they look for before they bring an FTC action is whether or not a brand has a social media policy. So you want to make sure that you have a social media policy. And if it's going to the influencer, or if it's going to the influencer parent, or if it's going to the influencer agent, or it's going to manager, you just got to make sure it's going to the correct people so that they can ensure that the influencer is going to comply with it.
Thank you. It looks like we have one last question from Peter, asking, how does the European Union differ from the U.S. rules?
It's very funny because it really FTC endorsement and the influencer disclosure really started in the United States. When I first started doing this, we had this broad, you know, comprehensive uh, legal basis for disclosures and laws that and regulations that applied, and all the other countries were trailing. Everybody was trying to catch up. They're sometimes following us, but say for something like UK, they were a little bit behind us. But my understanding is that they are more, they've caught up, but are probably more restrictive. I think there's really, in a lot of these countries, the word ad is almost required, as opposed to we have a little bit more flexibility. We have brand partner, brand ambassador, sponsored by brand. For a lot of particularly European countries, they're really focused on certain words, and one of them is ad and advertising. So I think the other countries have caught up to us when it comes to having some type of laws in place for laws and regulations for influencers. And I think they're more restrictive than us. So just be aware of that, because if you are, um, if your content is going into these other countries, it may not be sufficient to say sponsored by brand. You may have to do advertising by brand or ad, which is one of the FTC recommended disclosures, but it's not the only one. I think the FTC has given us a little more flexibility than probably what's going on in the UK and EU and some of the European countries.
All righty. It looks like we got one last question now. How do
Okay.
deepfake videos play in the legal arena?
Sorry, what was the last part?
How did deep fake videos play in the legal arena?
Um, well, in politics, there are certain, when for political advertising, there are certain disclosure requirements, even though they're not always followed. I think here's another area with deep fakes is where the law needs to catch up, similar to what we were saying about the FTC rulemaking and AI. I think deep fakes, we do need to have the law to catch up with, what's going on in the marketplace, because I think there are, more disclosure requirements in this area that need to be, enforced, and because there is something, just fake and deceptive about it, and I think this is an area where the law needs to catch up.
Great. Thank you, Allison. It looks like this
Thank you.
concludes today's presentation. Thank you so much for leading an excellent program today, and thank you so much to our audience for joining us today. Have a great day, everybody.
Thank you.